Staying for another year, but
Good afternoon.
with going on record, or do you have an introduction? Okay, you don't know. I'm just rebooting it. So sorry.
Tell me when we're ready. Good afternoon. We're on the record. This is the time and place set for the continued hearings before and meeting of the State of Nevada's Taxicab Authority Board. We're on the 1 o'clock agenda for September 17th, 2025. I will call us to order. The record should reflect that present are members Decker, Vice Chair Graff, and myself, Dan Research Chair. Member Vasquez has been excused for bereavement. I would ask that you join us in the Pledge of Allegiance, and Member Decker.
Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Having reviewed affidavits and confirmation of posting, it appears to me that this matter has been properly noticed and posted in accordance with NRS Chapter 341, the Nevada Open Meeting Law. Madam Secretary, do you confirm? The first item on our agenda today, item number 2, is public comment. This matter is on our agenda pursuant to Nevada's open meeting law for the purposes of taking comment from members of the public on matters within the jurisdiction of the authority board. We cannot take action on any of those matters, but we certainly welcome members of the public to make comment if they so choose. If there is any member of the public who wishes to address us under this public comment session, we'd ask you to come to the podium if you are present in Las Vegas. Seeing no member of the public who wishes to address us, Madam Secretary, is there anybody who wants to address us remotely?
No.
Seeing none, I will close agenda item number 2, our first public comment session. We have set on our calendar starting today 4 applications. Agenda items 3, 4, and 5 are applications related to pilot programs. Those matters will be heard at the earliest, starting at 9:30 a.m. in the morning. tomorrow, the 18th, or after the conclusion of the proceedings in agenda item 2. So if you are here only on a pilot program application, I will let you know that you don't need to be here until 9:30 in the morning. And no promises that we will start at 9:30 in the morning on agenda items 3, 4, and 5 until we conclude agenda item 2. Any questions from the board on that? Nope. It takes us to agenda item 2. This is the public hearing in the matter of the joint application of Desert Cab Company and ACAB Company. It is my understanding that ACAB Company fell out of this application, has moved itself from this application, and this application is to adjust taxicab charges to include a pass-through software license charge. We will take appearances at this time on behalf of the applicant.
Good afternoon, Mr. Chairman, members of the authority, Hui Kremsrud with Brown and Kremsrud on behalf of Desert Cab and George Halliday.
On behalf of CAP.
Afternoon, Robert Julius, Colin Farrell, attorneys for.
Captain.
I didn't hear the last. He said attorneys for,
Captain and Mr. Myers.
thank you.
On be
And just who's present with you,
Yes.
Mr. Myers.
Correct.
Thank you.
and on behalf of IVSCIP.
Good afternoon, Mr. Chairman, members of the board. Neil Tomlinson, bar number 6851 from Hyperion Advisors. I'm here on behalf of IVSCIP LLC, and with me is Noah Messel.
On behalf of Taxi Management and Kirk.
Good afternoon, Mr. Chairman, members of the authority, Scott Shearer, Brownstein, Hyatt Farmer Schreck, and on behalf of Taxi Management, YCS, Curve Mobility, Z-Trip. With us in the audience, Jonathan Schwartz, Michael Balin, Bill George, Cheryl Gibbons.
And on behalf of the administrator.
Good afternoon, Jessica Guerra from the Attorney General's office here on behalf of the administrator who is present with me.
A couple of preliminary matters before we get started. The first is anybody, are there any of the council present not in possession of the hearing exhibit list? You all have that.
On behalf of applicant, yes.
Just need to tell me if no, and has everybody got one? Remember, we're in an administrative proceeding, relax, stay seated. If you want to stand up and feel better about that. I would like to know if it is possible to stipulate some or all of these into evidence in advance. So I'm going to start with applicant, and if there's exhibits that you would not be prepared to stipulate to, if you could tell me that. My idea is to get as much of this in the record without yeah, no, that's fine. Stand these while you're looking, everybody look and see what it is we move in Moss to begin with. While you're looking, we'll cover confidential matter second.
We are prepared to stipulate to items 1 through 24.
Captain? You need more time, let me know.
Captain, sufficient position as the applicant.
IBSC,
We'd also stipulate those.
1 through 24.
Yes.
Taxi management and curb.
Stipulate to one,
15, Mr. Sheriff.
13, 14,
Oh, 13, 14.
15, one,
25. You don't need to go any further after 24 because I don't have anything else.
thank you, Mr. Chairman. If the other parties are willing, I would stipulate to disability of all.
Under. Just if I. So you're 1 through 7, 13, 14, 16 through 21. Administrator,
Mr. Chairman, the administrator has, if I may put it this way, has no opposition to any of the exhibits. Yeah, so no opposition to any of the exhibits.
with that, if either of my colleagues have a concern, I would, for the record, accept and as admitted exhibit 1 through 7.
Agree.
13 and 14. 16 through 21. Anybody comment on that? Comment. Give us a moment so we can keep ourselves straight on this. One through 7, 13, 14, 16 through 21. And
Mr. Chairman, after caucusing with the others, we will accept Mr. Scherer's offer and stipulate to everything.
oh. Okay, great. So I like caucus. So let's, yeah. This is a Dan problem, Ms. Webb. I need, do you have another copy? I don't have the witness or the exhibit list with the additional items. I don't know. That looks okay. Pick a new one? Oh, I see. Okay. Operator error. Sorry, I don't need that. Okay, so with that offer, and I'm assuming the administrator is okay with that position, exhibits 1 through 45 were admitted. We're going to be off to the races. I do want to cover, for the record, the confidential items, things that were marked confidential when submitted. It is the board's understanding, so somebody correct me if our understanding is incorrect. There was not an NDA or other arrangement among the parties for the use of items that were marked confidential, which are 13, 14, 20, 42, 43, 44. So it's our understanding confidentiality was claimed, and the parties have not shared that information with one another. The reason I'm asking this is we received briefs with some of this stuff attached to the briefs, so we're kind of not sure we understand what we need to do as far as public records. So is Exhibit 13 confidential anymore?
Yes.
Captain?
We have, and it is.
It is, okay. Is Exhibit 14 still confidential?
Yes, it is.
Okay. Exhibit 20.
Yes, it is.
The rest of these are to the applicant, 42, 43, and 44, various permutations of the required financials.
Yes.
But I say, Mr. Chairman, we have no objection. But we've not received a copy of the financial statement.
Yeah, understood. That's why I asked if there was an MBA. So our perception is that there has not been an exchange of these items, so they are still claimed to be confidential.
We have received the other documents.
Okay,
Processing discovery.
right. So for the purpose of the record, exhibits 13, 14, 20, 42, 43, 44 shall be deemed confidential and not part of the public record. And make the following record for public on that. Exhibit 13 is subject to confidentiality because it is a trade secret or other confidential commercial document indicating a customer list. Exhibit 14 is the form of a master software license that Captain has with a number of other folks, which has confidential financial and commercial terms, and therefore is likewise protected under Nevada law, either 604A or under common law, it being having particular commercial import to the parties. Exhibit 20 is similarly a confidential release and settlement agreement. It is in draft form, and it reflects negotiation positions of parties that have been reached in confidence, and also contains commercial sensitive information. Does any council want to supplement any of that information on the record for 13, 14?
It's
Exhibit 42, 43, and 44 are financial statements that are required by law to have been submitted with the application by Desert Cab and contain sensitive financial information about the operations, costs, expenses, profits of that business. And its submission under 706 is protected as a confidential item and will be so treated. So 42, 43, and 44 will likewise be confidential and were submitted not really at the, there was not an option whether to provide those or not to the board. And it is routine for the board to receive such financial statements and not make them public. Any supplement on that, Mr. President? So those items will be held in confidence. Attorney General's office. Okay with me. Okay. Before we take open statements, there are a few preliminary issues that the board would find helpful to have confirmation or clarification of based on what we have seen in evidence or in briefs. I'm going to, in briefs or in evidence. Going to try to state these as propositions that you can either tell me you agree with or you disagree with so that we can do this relatively quick. The first proposition is that the board does not have jurisdiction to determine the validity or the enforceability of a patent. Does any council disagree with that proposition?
no forgot.
Not seeing any disagree. Second proposition is that in this case, the jurisdiction of the board is to make a final decision on an application to adjust, alter, or change a rate, charge, or fare for taxicab authority pursuant to NRS 706-8819. That is the basis of our jurisdiction. Anybody disagree with it? Seeing none. The third proposition is that the board's jurisdiction to impose a technology fee under NRS 706.8826 subsection 4 is not relevant in this case because such a fee must be deposited with the state treasurer and may only be applied or used by the state of Nevada to fund the authority. But you disagree with that?
Mr. Chair, could you just say the citation again for the
Yes.
706 section?
706-8826 subsection 4. Technology fees go to the government, not to a private party. The following is not a proposition, it's a please help us understand. In briefs and in testimony, there are citations to NRS 706-151 and 706-15163 as somehow relevant to the taxicab authority board. although those statutes are not part of our statutory scheme. They are part of the statutory scheme for the Transportation Service Authority. So to the extent that you have relied on those sections, it would be helpful for you to tell us now why we would consider relevant those statutes or any testimony or evidence related to the applicability or an evaluation, whatnot, under those statutes. Anybody disagree with the proposition that those are not part of our scheme? Not relevant? Yeah. Tom.
Yeah, I mean, I think that they're certainly relevant for discussion. What section 151 is an overall declaration of purpose by the legislature. I think that covers all of 706, not just the part dealing with either the NTA or TA. So I think it's an overriding purpose of why those statutes are there. So I think that's certainly relevant to that discussion about those. The other one I think is relevant just to show that the legislature has made moves related to technology, and I think it's applicable to discuss. I don't think it's binding, and we're not saying it's binding that one particular, but I think certainly relevant for discussion, not necessarily relevant to the final determination.
Anybody else want to make?
Mr. Chair, if I may, this is for the record, Jessica Guerra, the Attorney General's office. I don't recall the second citation, but 706.151, at least from the position that I've seen it personally, is that it's kind of like an umbrella statute that discusses the legislative purpose for 706 overall, but then the actual statute chapter itself breaks down for the two different transportation authorities. So I think it's important as far as giving maybe like an umbrella understanding, but then each agency has its own section within the chapter that it's expected to adhere to.
Any other guidance or help on that? Great, that's very helpful. Thank you. Yes, Counselor.
Sorry. I think that the applicability of this statute bears on testimony of Mr. Hessel. He made the point that this system and those requirements are binding on all operators and certificate holders under Nevada law. And from his point of view, that reads on, he gave an exemplary patent, did a claim by claim analysis. And that is relevant, I think, in this case, two purposes. There are some comments, although not supported by witnesses, that other technology doesn't infringe, even if IDSC says CAPTA does. Mr. Vessel pressed that, it's relevant for that purpose. And secondly, if someone is going to come into Nevada and provide technology to certificate holders in Clark County, they're going to have to comply with that statute. They're going to run into that, the IVSC patents if they do that. And there's some discussion about other suppliers, AutoCab and others. This includes Curb, which is already present in the county. And it's relevant for that purpose. And if their statements are to give it, if you're going to ignore those statements entirely, then the only testimony is that Mr. Messel, that all technology providers that provide this type of technology promulgated by statute going to involve implication of these patents. That's
okay.
That's part of what the proceeding is going to look at.
So that's understood. That we now have joined, I think, that there is an issue and we're going to have to resolve that issue of law. Mr. Chairman.
I think that's there's an issue of law. We don't agree with the points that have been made by. We have to preserve that.
Understood. We're just trying to figure out clear the decks of things that we don't have to. That is now on our list of got to worry about. The Attorney General, on behalf of the administrator, has raised the issue of whether the application is seeking hypothetical or speculative relief. And for that reason is not ripe for adjudication. Specifically, the application is not, or the applicant has not incurred cost of providing service. And if relief is granted, would never incur cost of service because that cost is going to be directly imposed on ratepayers. I would like to hear from each council briefly about whether we have a ripeness problem that would make going through a couple days of hearing a worthless task because we're not really able to reach the issue, or if everybody other than the Attorney General's office thinks it's ripe and ready to go, just tell us. We just know an issue has been raised and we want to know whether we're facing some issue. So I'm happy.
There is a justiciable controversy here. I think the pre-filed testimony submitted shows that fees and costs have already been incurred at the outset of the application and the amended application. In addition to that, the threat of litigation, the threat of exorbitant costs, the uncertainty puts the issue at the forefront to address it now. The dispute started in 2021, and the parties have brought forth a concrete claim that needs to be addressed by this proposed rate increase. This is the way this matter is resolved versus forcing a patent lawsuit, forcing the industry to incur exorbitant fees and costs, and in essence, putting all of the operators at risk of financial harm and insolvency.
Captain?
We would, Mr. Chairman, we would join the applicant's point.
IDS.
Chairman, members of the board, Neil Tomlinson, again, on behalf of IBSC IP. We join in that, and I would just add that, this really, in my opinion, is where NRS 706-151 comes into play, because there's a section in there. And as the Attorney General said, it's kind of an umbrella that covers really both agencies and all of 706. Section 1C says that the purpose of this whole chapter is to provide for fair and impartial regulation, to promote safe, adequate, economic, and efficient service, and to foster sound economic conditions in motor transportation. And we believe that that is exactly on point with the question that was posed here, because we certainly do think it's right, because there has been a demand by IBSC IP to Captain that directly impacts all the certificate holders. So we do think that it's absolutely right.
We agree with General Strader. The draft license agreements are just that, draft. No one has signed them. No one has agreed to them. Even the applicant, Mr. Balaban, in his deposition testimony, said that he had not agreed to the license agreement, at least as of that point in time. So we do think there's a ripeness issue here. It's the only costs that have been incurred are costs to bring this proceeding. Not by the only costs incurred by the applicant are costs to bring this proceeding. The only threats made by IBSC have been to Captain, who is not a certificated operator.
Sarah? Yes, please.
Jessica Guerra, on behalf of the administrator, as you have read in my pre-hearing testimony, at least from the evidence that we have seen, because ultimately it's going to be your decision on whether or not you think it's actually ripe to be heard. But I think that this case essentially expects you to kind of assume certain facts, and at least for the position of the administrator, we're not inclined to assume those facts. So ultimately, it's your decision. I do think it's something that is up for dispute because it has been objected to by other parties, which again is up to your discretion of how far you want to hear this. But we just wanted to bring that point because again, from our position, there seems to be a lot of assumptions that are expected to be made in order to reach this rate determination.
Um, Final point, unless my colleagues have something. Taxi management and Kerr Mobility have raised the issue that there's a notice defect that prevents the contested case from proceeding because the application omitted disclosure that Captain or another similarly situated technology provider would receive 25% of the rate if approved, that would be passed through to ratepayers. I'd like to hear from council on whether I have a notice problem. This kind of issue is not academic in my opinion. It has stopped dead in its tracks a number of public utility commission cases making rates. So I want to know that if there's some kind of defect in the notice, we flesh it out for the record now.
On behalf of applicant, we do not believe that there is any defect in notice. The apportionment of the 12.5 cents occurred during the discovery process to which every party was on notice. In addition to that, we provided a supplement to the application, which relates back to the original underlying amended application. So to the extent that there's any claim of lack of notice, it's all public record and it relates back to the original.
Captain,
We would agree with the applicant.
IDSC.
We also agree, Chairman, and it's certainly an impossible endeavor to initially notice any type of application to cover every little thing that may come up in hearing, but the 50 cents was certainly within the notice, and certainly that's what's that issue here.
Just share with Mr. Tomlinson, I made that same argument and lost it from the public utility. Mr. Victor.
Obviously, we believe there is a notice issue. It's not just regarding the parties, but the public notice is for those who might wish to try and intervene. And so we believe there is an issue here. One of my clients is not an intervener, is not a party, although obviously they're represented. But because they did not get, they were not, did not intervene before the original deadline. If this had been noticed appropriately, other technology providers might want to come in to intervene. So I think there is a notice issue here.
Chairman, in my brief caucus with the administrator, he thinks that it's an issue because not everyone has access to all the records that were produced in this matter. It's not exactly the most, while it is public record, everything is not exactly the most accessible or the most noticed when going through an administrative proceeding. So I think the question that is in front of you is whether or not other interveners would have filed in this case if they had known of the fee breakdown, or if that is actually an issue at this point versus the 50 cents overall issue.
My only thought on that, council, is the cases have been that the original public notice is not adequate to put a party on notice that they should be a participant. I think that was Mr. Scherer's argument, and I understand that. I don't think that a notice is somehow retroactively efficient, with all due respect to the administrator, because discovery or in the course of litigation, other information becomes known to parties. I think that the issue, as I understand it, Scherer's arguing is that there was to be an allocation and that the whole 50 cents was not going to be compensation for an alleged infringement of patent is the nub of the problem. Turns out that only 37.5 cents is going to be used for that purpose, and 12.5 cents is going to be used for some other purpose. So my question to Mr. Scherer is by reopen intervention now, does somebody want to intervene? Not saying I will, but
Understood. Chairman, as I mentioned, one of my clients, C-Trip, would have intervened had they not missed the original deadline. Whether others would intervene based on the allocation, I don't have anyone in particular. I haven't gone out and solicited the industry to see who else might intervene, but it is entirely possible, especially in light of the allegations that made in this case.
Thank you.
And the fact 12.5 cents would just go, frankly, it's not very clear where the 12.5 cents would actually go, other than the technology provider to use as they wish.
Thank you.
Sheriff.
Oh, it's Tom.
If I make one comment. Neil Tomlinson again on behalf of IBSC. I guess, my thinking when I heard Mr. Shearer say that is that I don't know how you could say that technology provider would be somehow disadvantaged or harmed, because it's actually, there's now a part of that fee that would go to them. So if anything, they'd be benefited by it. Certainly no prejudice to them in my thought process anyway, as far as how the fee's broken down. So I don't know how the party could say that they were somehow prejudiced by that.
Understand that position. I think I don't think that the cases that have been determined, at least in the Public Utilities Commission space, have so much looked at the prejudice issue as there's just a requirement of a kind of notice to be given under the statute. Need anything?
Mr. Sure, is your objection as to the original notice, or is your objection as to the 12.5 cents particular?
It's as to the second amended application, adding the 12.5 cent allocation. Again, could have been a technology provider, could have been a certificated operator who thought that, well, if it's going to go to pay a royalty, save us from infringement, I'm okay with that. But if a quarter of that's actually a technology provider, I already pay my technology, I'm not okay with that. And they may have wanted to give it.
I may respond to that point. The second amended application was properly filed and publicly available, satisfying NAC 706-909. And in addition, I would state that in the normal course of proceedings, pleadings, applications are often amended to conform to the evidence. This would be one such situation. As the allocation of the fee arose during the process, it was supplemented and made publicly available. So the notice itself that was provided at the outset gave adequate notice that there was a fee that was on the table for an increase. And the second amended application provided for further clarification of what that fee would be.
Last calls for anybody who wants to make any supplemental record on this particular issue before we move on. Thank you. With those predicate matters, is there any other predicate matter that we need to consider before we take opening statements?
If I might, Mr. Chairman, I'll make this offer to all of my fellow council. I've mentioned some, as far as I'm concerned, we've all had an opportunity to submit pre-file testimony, an opportunity to depose the witnesses. And most of those witnesses were in fact deposed. We had an opportunity then to file supplementary written testimony and supplemental exhibits. All of that's been done. We've now stipulated to admit admissibility of those. On our part, we would be willing to dispense with essentially presentation of additional evidence and witnesses and the reading of written testimonies into the record, which the regulations allow, and frankly move straight to arguments as to why or why not, based on that evidence, this absolute charge should be removed.
Take that as an offer to stipulate, and go around the room and see where we're at.
I'll respond last. That's okay.
Well, actually, the administrator will respond last, but go ahead.
As far as the parties.
Cap.
Had a discussion with, so about that very subject yesterday. It also these outlines this morning, this afternoon. I don't think it's appropriate. Several reasons. Some of the many of the witnesses who have submitted pre-file testimony have been deposed, but not all of them. Number one. Number two, you would approach a deposition differently than you would examination and trial. And for some of the witnesses, I can speak my point of view, I would cross-examine them in a different way than questions I asked. Position, narrative, get the side of the story and hear about it. But to have all the parties forego that opportunity, I think is unfair and inappropriate. And the hearings set for 2.5 days envision this type of examination I think are about to embark on.
So given there is one objection, I don't think I need to hear other objections. Thank you, Mr. Sheriff, for that attempt, and thank you, council. Unless there's some other information that is necessary, if one party wants to proceed, I don't think we have the ability to not allow that to happen.
I might try a more limited stipulation, Mr. Chairman,
Okay,
which is simply to dispense with the reading of the written testimonies.
so you don't need to make that. It's going to be the presiding officer's ruling that I will qualify each of the person's direct testimony, and we will be going straight to cross-examination after that. We'll be using the standard rules of the Public Utilities Commission, which are standard practice, not rules, to expedite the proceeding. So appreciate that offer, but nobody gets to read the testimony. We've all had it. We've all had it since the day you filed it. Because we're very excited to read the testimony. Okay, any other predicate matter? Before we get started, we're going to take a break till 1:55.
Mr. Chairman, do you mind if I move there? Everybody's back this in the air. I was talking.
Well, that's